1860. 2 land grants, identical size, same origin, opposite destinies, 100,000 acres each, both selected by the same attorney on the same day, both approved by Congress through the same process. Today, one is Arizona's largest private landholding, cowboys ride, cattle range, boundaries unchanged for 165 years. The other became 150 families evicted by U.S. Marshals in the night, houses emptied, years of work erased, legal warfare until 1977. Same congressional act, same attorney, same approval process. Did the law work or did it break? If you enjoy deep investigations into Western land history, the legal battles that shaped ownership, and stories of communities that disappeared from maps, subscribe now and tell me in the comments which controversial land grant we should investigate next. Your support makes these detailed stories possible. Let's begin. To understand what comes next, go back to 1821. Don Luis Maria Cabeza de Baca petitioned the Spanish colonial government for a land grant in what would become New Mexico, 500,000 acres of prime grassland near present-day Las Vegas. The provincial deputation approved it. The alcalde delivered formal possession. The Baca family began running sheep. The grant came at the end of Spanish rule. Within months, Mexico won independence. The legitimacy of grants issued in that transition became questionable. Comanche raids made the land dangerous. The Baca family used portions of it but never fully occupied the entire grant. Don Luis was killed in 1827 in a dispute over contraband pelts. His heirs maintained some presence. The land remained largely empty. In 1835, a separate group of settlers petitioned Mexican authorities for a community grant covering essentially the same land. They claimed it was vacant public domain. The Mexican government approved their petition. The town of Las Vegas was founded. 2 grants, same land, both apparently legitimate under different authorities. The Baca heirs protested. By the time the United States took control of New Mexico in 1846 through the Treaty of Guadalupe Hidalgo, Las Vegas had grown to roughly 2,200 residents. The Baca family claim existed on paper. The town existed on the ground. The United States government pledged to honor legitimate land grants from Spanish and Mexican rule. Surveyor General William Pelham examined both claims in the late 1850s. He concluded both were valid. Congress faced a choice in 1860: evict 2,200 people from an established town, or compensate the Baca heirs with land elsewhere. Congress chose compensation. The Las Vegas settlers could stay. The Baca heirs would receive equivalent land, 5 tracts of 100,000 acres each, to be selected from vacant, non-mineral public land within New Mexico territory. 5 floats. Land grants not yet located by survey floated to new locations from the original claim. The Baca heirs needed someone to make the selections. They retained their attorney, John Sebree Watts. John Watts came to New Mexico territory in the 1850s, Indiana-born, law-trained. By 1860, when Congress authorized the floats, Watts was New Mexico's non-voting delegate to Congress. He helped draft the legislation creating the float system. He advised the Baca heirs on their options. He selected their land. Float number 1, Jemez Mountains, west of Los Alamos. Float number 2, High Plains north of Tucumcari along the Canadian River. Float number 3, Santa Cruz Valley in southern Arizona Territory, north of the Mexican border. Float number 4, San Luis Valley in what would become Colorado, near present-day Crestone. Float number 5, High Desert northwest of Prescott in central Arizona Territory. 5 parcels, each roughly 12.5 miles square, each supposedly vacant, each supposedly without mineral value according to the congressional requirements. Watts made the selections in his capacity as the Baca heirs' attorney. Less than a month after the government approved the floats, Watts purchased floats 2, 3, and 4 from the Baca family, 300,000 acres. Purchase price, $3,000, 1 cent per acre. Separately, he bought float number 5 for $6,800. The Baca heirs, who had just lost a 500,000-acre grant and received 500,000 acres in compensation, now owned only float number 1. Their attorney owned the other 400,000 acres. Total amount Watts paid for land Congress had granted his clients, $9,800. The transaction was legal. The records exist. Whether the heirs understood the land's potential value remains unrecorded. What Watts told them about the float's worth went undocumented. Watts later sold float number 3 to William Wrightson, president of a mining company, for $110,000. The law required non-mineral land. A mining company president purchased it. Watts operated within a network later historians would call the Santa Fe Ring. Lawyers, politicians, and businessmen who recognized that New Mexico Territory's transition from Mexican to American law created opportunities for those who understood both systems and had access to power. Watts served as Territorial Attorney General. He was elected delegate to Congress. President Andrew Johnson appointed him Chief Justice of New Mexico Territory's Supreme Court. At each position, he acquired information about land grants, their status, their disputed boundaries, their potential value. His land dealings extended beyond the Baca floats. Records show involvement in more than 30 separate land grant claims across New Mexico and Arizona territories. He purchased interests. He represented claimants. He advised on selections. He drafted legislation. The lines between these roles blurred continuously. When he selected the 5 Baca float locations in 1860, Watts possessed knowledge few others had. He knew which lands contained minerals, despite requirements they be non-mineral. He knew which surveys were incomplete or disputed. He knew which areas the government might challenge and which would likely pass without scrutiny. He knew because his positions gave him access to that information. The purchase of 4 floats from his clients for $9,800 represented one transaction among many. But it established a pattern. Use legal expertise and political position to identify valuable land, acquire it cheaply through clients who lack full information about its worth, and hold or resell for substantial profit. Other members of the Santa Fe Ring operated similarly. Mariano Otero, who would later acquire Baca Float number 1, specialized in such transactions. Thomas Catron accumulated millions of acres through similar methods. These men understood that territorial New Mexico's confused land title system created opportunities for those with legal knowledge and political connections. The Territorial Surveyor General's office processed land grant claims, but it was understaffed, underfunded, and relied heavily on claimants to provide documentation. Attorneys who knew what documentation would be accepted and what questions wouldn't be asked held enormous advantage. Watts knew. He selected Float 3, covering existing communities and mineral deposits. He certified it as vacant and non-mineral. The government approved his selection. Whether officials didn't check or chose not to challenge a congressional delegate's application remains unclear from the record. The transaction was legal under territorial law as it existed. Whether it was ethical by any standard is a different question the record doesn't answer. Watts's documented land interests by 1870 exceeded 1 million acres across New Mexico and Arizona territories. His involvement in land grant cases, over 30 separate claims. Float 3 sailed to Wrightson, $110,000 in 1864. Purchase price from the Baca heirs as part of the 3-float package, $1,000. Return on float. 3 investment, 11,000% in 4 years. Float 5 sold for $6,800. Watts died in 1887, his estate holdings spanning 3 territories, total value unrecorded in public probate documents. Watts selected the Santa Cruz Valley for float number 3 in 1863. The application stated the land was entirely vacant and non-mineral to his knowledge. The float encompassed parts of Tubac, a settlement founded as a Spanish presidio in 1752. It included Tumacacori, site of a Spanish mission established in the late 1600s. It covered Calabasas, a community that had developed around ranching operations. The Salero mine, known for silver deposits, fell within the float's boundaries. The selection appeared to violate congressional requirements. Vacant land. Non-mineral land. The government approved the float. The Santa Cruz Valley, where Watts located Float 3, ran north from the Mexican border through what would become Santa Cruz County. The float's boundaries encompassed approximately 100 square miles in a rectangular tract. The Santa Cruz River flowed through the western portion intermittently, seasonal flow dependent on monsoon rains and snowmelt from surrounding mountains. The Santa Rita Mountains rose to the east, peaks reaching over 9,000 feet. The Tumacacori Mountains formed the western boundary. Between them, grassland and mesquite bosques stretched across the valley floor. The elevation ranged from 3,200 feet in the valley to over 8,000 feet in the mountain foothills included in the float's eastern edge. This elevation variance created multiple ecological zones: desert scrub in the valley, oak-juniper woodland at mid-elevations, and ponderosa pine and Douglas fir on the higher slopes. Water determined settlement patterns. Tubac occupied a site near the river where Spanish authorities had established a presidio. Tumacacori Mission sat on slightly higher ground near a reliable spring. Calabasas developed around ranch headquarters with access to seasonal creek flow. The Salero mine operated in the foothills where ore deposits outcropped. By 1860, when Watts made the selection, Tubac's population fluctuated between 150 and 300 people, depending on Apache raid frequency. Tumacacori Mission had been abandoned, but the buildings remained standing, used occasionally by travelers. Calabasas consisted of perhaps 50 residents clustered around ranching operations. The Salero mine employed between 20 and 40 workers, depending on ore quality and silver prices. Total population within the float's eventual boundaries was approximately 300 to 400 people in established communities, plus seasonal workers, prospectors, and travelers passing through. William Wrightson paid $110,000 for the grant in 1864. In 1866, Apaches killed Wrightson and his surveying companion Gilbert Hopkins in the Santa Rita Mountains. The 2 highest peaks in the range are named for them. The float's ownership passed to Wrightson's heirs and various speculators. The exact boundaries remained uncertain. Different surveys gave different results. Mineral deposits attracted prospectors, and communities within the float's claimed area continued growing. Wrightson had purchased the float intending to develop the mineral deposits systematically. After his death, ownership fragmented among his heirs. They sold portions to different buyers. Some parcels went to ranchers, some to mining companies exploring the silver deposits, and some to speculators holding land for future appreciation. Through the 1870s and 80s, the float's status remained unclear. Different surveys gave different boundary descriptions. The Department of the Interior's General Land Office issued conflicting guidance about which lands fell within the float and which were public domain. Settlers arriving in the 1890s and early 1900s couldn't determine from government records whether specific parcels were open for homesteading. The Land Office itself couldn't provide definitive answers. Survey markers were missing or disputed. Legal descriptions from different documents didn't align. In this confusion, people made decisions about where to build their lives. By the early 1900s, homesteaders had moved onto land they believed was open public domain. The Department of the Interior's General Land Office had confusion about which parcels fell within the float and which didn't. In 1907, the Commissioner of the General Land Office ruled the float's amended location was invalid. In 1908, the Land Office opened Float 3 to homestead entries. Settlers came. They filed claims according to federal procedure. They built houses, barns, corrals. They cleared land, planted crops, ran cattle. They proved up their homesteads according to law, spending the required years in residence, making the required improvements. The families who filed homestead claims after 1908 came from different backgrounds but shared similar goals. Own land, build something permanent, escape wage work for independence. Some had farming experience in other states. Some had worked as ranch hands, saving money for their own place. Some were immigrants, seeking the American promise of land ownership. All followed the procedure the General Land Office published. File a claim on an available quarter section, 160 acres. Pay the filing fee. Build a residence within 6 months. Live on the land for 5 years. Make improvements proving cultivation or development. Submit proof of compliance. Receive patent transferring ownership from the United States government to the claimant. The Land Office's 1808 decision opening, Float 3, to homesteading appeared clear. These parcels were available. The float's disputed status had been resolved against the speculators. Public domain could now be claimed. Families arrived. They selected parcels with access to water or good soil or proximity to existing communities. They filed paperwork according to regulations. They began building. A homesteader might arrive in spring with a wagon, basic tools, seed, and enough provisions to last until first harvest. First task? Shelter. Adobe construction was common. Mix clay soil with water and straw, form into bricks, dry in sun, stack into walls, wooden roof beams supporting dirt roof, or, if money allowed, corrugated tin. Simple structure, 1 or 2 rooms. Cost, perhaps $50 in materials plus labor. Next, water development. If no stream crossed the property, dig a well. By hand, using shovel and pick, through calichet and rock. Depths varied. 15 feet if you were lucky and hit water table quickly. 50 feet or more in drier areas. Line with stone or timber to prevent collapse. Install hand pump if you could afford one. Otherwise, rope and bucket. Cost, $100 to $200 depending on depth and whether you hired help. Then, fencing. String barbed wire around the boundaries of your claim to establish your acreage and keep cattle from wandering. 4 strands of wire on wooden posts set every 10 to 15 feet. For 160 acres, you'd need approximately 3 miles of fence. Wire cost money. Posts you could cut from available timber. Total materials, $100 to $150. Labor, weeks of digging post holes in rocky soil. After infrastructure, cultivation. Break ground for crops if you planned farming, plant grass if you planned ranching, maybe plant fruit trees hoping they'd mature during your 5-year proving period. Build corrals if you owned livestock. 5 years of this work. 5 years of residence. 5 years proving you were developing the land according to homestead law requirements. The improvements were substantial, not grand, but real. A family that completed proving up had invested perhaps $1,000 to $2,000 in direct costs, plus 5 years of labor, plus the opportunity cost of what they could have earned working elsewhere during that time. They had proof. Receipts for wire and nails and seed, photographs of the house and well and fencing, affidavits from neighbors confirming residence, everything the General Land Office required to transfer title. Homestead claims filed on Float 3 lands between 1908 and 1914, 170 to 200 based on Land Office records. Claims remaining in residence when the Supreme Court ruled in 1914, 120 to 150 families. Total fencing installed across all claims, 480 miles. Cleared land, 8,000 acres. Total investment by all homesteaders combined, $120,000 to $180,000 in direct costs. Average family size, 5 to 6 persons. Total population living on Float 3 homesteads by 1914, 600 to 900 people. The Supreme Court ruled against them while families were still fulfilling their 5-year proving requirements. Some families lived there for more than a decade. The speculators who claimed to own the float carried their case through appeals. The litigation path from the Land Office's 1907 ruling to the Supreme Court's 1914 decision passed through multiple jurisdictions and procedural stages. The speculators who claimed ownership under Wrightson's purchase argued several points. First, Congress had authorized the Baca floats in 1860. Second, the float selections had been approved through proper procedures at that time. Third, subsequent government officials lacked authority to invalidate what Congress had authorized. Fourth, property rights once granted couldn't be revoked simply because later review revealed irregularities in the original selection. The government's position, represented by the Commissioner of the General Land Office in 1907, focused on different ground. The law authorizing the floats required vacant, non-mineral land. Float 3 clearly contained communities and minerals when selected. This violated statutory requirements. Therefore, the selection was void. The land should revert to public domain available for homesteading. The case turned on technical questions about administrative authority and retroactive application of standards. Could officials in 1907 determine that officials in 1863 had improperly approved a selection? If so, what happened to intervening property transfers made in good faith, relying on the government's approval? The speculators had purchased the float believing title was valid. They had paid taxes on it for decades. They had made improvements and lease arrangements. If the government now declared the original grant invalid, did that protect the speculators' investment or void it? The case moved through the Department of Interior's internal review process. The Land Office Commissioner ruled against the speculators. The Secretary of Interior upheld that ruling. The speculators appealed to Federal District Court, arguing the administrative decisions exceeded authority. District Court ruled for the government. The float selection had indeed violated requirements. Administrative officials had authority to correct such errors. The land would be opened to homesteading. The speculators appealed to Circuit Court. Circuit Court affirmed the District Court ruling. The float was improperly selected. Opening it to homesteading was appropriate remedy. The speculators appealed to the United States Supreme Court. They hired prominent attorneys experienced in land grant litigation. They prepared extensive briefs arguing property rights, congressional intent, administrative limits, and the unfairness of destroying title that government approval had created. The Supreme Court heard arguments in 1913. The decision came down in 1914. Justice wrote for the majority that while the float selection appeared to violate statutory requirements, Congress had authorized the float system, and administrative officials had approved this particular float. Subsequent officials couldn't void that approval without congressional action. The government's approval, even if improperly granted, created property rights that subsequent administrative review couldn't destroy. Therefore, the float was valid. The speculators held legitimate title. The homesteaders, who had filed claims after the land office's 1808 decision, had done so on land that wasn't actually available for homesteading. The ruling acknowledged the hardship this created for families who had relied on government guidance when filing their claims. But property law protected the float owners' rights. The homesteaders would need to seek relief from Congress, not the courts. Dissenting justices argued the majority elevated procedural approval over substantive law. If the statute required non-mineral land and the float contained minerals, administrative approval couldn't make an invalid selection valid. But the dissent didn't prevail. The decision was final. The float belonged to the speculators. The homesteaders were trespassing. In 1914, the United States Supreme Court ruled in their favor. Baca Float Number 3 was legal. The amended boundaries were valid. Every homesteader who had filed claims under the Land Office's 1808 decision was there illegally. The evictions began in 1917. United States Marshals arrived with court orders. Families who had lived on the land for years received notice. Some were given days. Some were given hours. Marshals served notices at night. Families were removed. Houses were emptied of furniture and possessions. People who had invested everything in proving up their claims under federal homestead law lost access to the land. More than 150 people were forcibly removed. The improvements they had made to the property remained. The years spent working the land were not compensated. They had followed federal law as published in 1908. The Supreme Court ruled that law had been issued in error. In 1921, Congress passed the Act for the Relief of Settlers, authorizing the evicted homesteaders to claim new lands elsewhere as compensation. Most did not exercise that right. Legal disputes over Float 3 continued. Boundaries remained contested. Ownership fragmented as speculators sold portions to various buyers. Mining operations came and went. Communities persisted in some areas. The float achieved final legal resolution in 1977, 114 years after Watts made the selection. Today, Baca Float Number 3 exists as separate parcels. The fragmentation of Float 3 across the 20th century created a patchwork reflecting different economic uses and different historical moments. Rio Rico occupies the southern portion. Development began in the 1960s as a planned community. Residential lots, golf course, commercial areas. The development marketed itself as affordable retirement living near the Mexican border with access to Tucson and Nogales. Population grew from essentially zero in 1965 to approximately 20,000 by 2020. The development sits on land where Calabasas once stood, where homesteaders were evicted in 1917, where speculators who won the Supreme Court case eventually sold to developers who saw residential potential. Tubac to the north evolved differently. The old Presidio town became an arts community. Galleries, studios, restaurants catering to tourists from Tucson. Population remains small, under 1,000 permanent residents. But tourist traffic brings economic activity. The town occupies land that was within Float 3's boundaries, land that Watts certified as vacant when he made the selection. Tumacacori National Historical Park preserves the Spanish mission ruins. The National Park Service acquired the land in 1908, ironically the same year the General Land Office opened Float 3 to homesteading. The mission site was deemed historically significant enough to warrant federal protection. Current park size, 360 acres. Annual visitors, approximately 40 to 50,000. Between these nodes, private ranches and rural residential properties fill the remaining acreage. Some parcels trace back to homesteaders who managed to purchase land after the evictions through private sales from the speculators. Some parcels were sold in the 1920s and 30s to ranchers consolidating holdings. Some became residential lots in recent decades. The legal resolution in 1977 settled the last boundary disputes. But the human cost of the century-long controversy doesn't show in current land titles. Rio Rico population as of 2020, 20,000 residents. Housing units in Rio Rico, 7,000. Total assessed property value for all former Float 3 lands, $2 to $3 billion. Tumakakori National Historical Park, 360 acres. Annual park visitors, 43,000. Tubac population, 950 permanent residents. Tubac tourist visitors annually, 200,000 to 250,000. This compares to William Wrightson's $110,000 purchase price in 1864. While Float 3 moved through fraud allegations, litigation, and forced removal, Float 5 took a different path. 50 miles northwest of Prescott in 1860, the land Watts selected was vacant. High desert plateau stretching between the Santa Maria River and Big Chino Valley. Jagged canyons, mesas rising from grassland, elevation ranging from 3,000 to 8,000 feet. Ponderosa pine on the heights, juniper and scrub oak lower down. No established communities. No known mineral deposits significant enough to attract mining operations. The selection met congressional requirements as written. The landscape Watts selected for Baca Float number 5 occupied high desert plateau in what would become Yavapai County. The float's rectangular boundaries encompassed 100,000 acres in terrain that varied dramatically across short distances. Elevation ranged from approximately 3,000 feet in the lowest valleys to 8,000 feet on the highest mesas. This 5,000-foot variance created distinct ecological zones stacked vertically across the property. At the lowest elevations, Sonoran desert species dominated. Saguaro cactus in protected southern exposures, ocotillo, prickly pear, cholla, creosote bush on rocky slopes, limited grass cover except after good monsoon seasons. Between 4,000 and 6,000 feet, grassland opened up, grama grass, tobosa, various bunch grass species. This was grazing country when precipitation cooperated. Dry years meant sparse forage. Wet years could support substantial cattle numbers. But water remained the limiting factor. Above 6,000 feet, juniper and pinon pine appeared. Then ponderosa pine at 7,000 feet, Douglas fir on the highest peaks. The higher elevations received more precipitation, both summer monsoons and winter snow. Springs emerged where geology allowed water to surface. Water sources scattered across the landscape determined where cattle could range. Natural springs in the mountains, seasonal streams running during monsoon, dry washes that held water in pockets after storms. But much of the acreage lacked reliable water except during wet periods. The terrain was rough. Canyons cut through mesa country. Rocky outcrops made riding treacherous. Box canyons where cattle could trap themselves required local knowledge to navigate safely. The land didn't yield easily to any use. No communities existed within the float's boundaries when Watts made the selection. The nearest settlement was Prescott, roughly 50 miles southeast. A few prospectors may have passed through looking for mineral deposits, but no established mines operated within the float. No ranchers had claimed the land. No homesteaders had tried to prove up claims in country this difficult. The float met congressional requirements. Vacant, non-mineral in any commercially significant sense. Available for selection. The lack of water development infrastructure meant the land had limited value in 1860. Without wells or tanks or pipeline systems, running cattle at scale was impossible. A buyer would need to invest substantially in water infrastructure before the land could support ranching operations. This explains why the float sold for relatively low prices in early transfers. Edward Perrin paid an undisclosed sum in 1880, likely modest given the lack of development. The land had potential. But realizing that potential required capital investment, Perrin apparently wasn't prepared to make. The float sat largely unused for decades after Perrin's purchase, perhaps limited grazing by neighboring ranchers whose cattle drifted onto the unfenced range, perhaps occasional hunting. But no systematic development occurred until the Greene Cattle Company's purchase in 1936. The float's physical characteristics: 100,000 acres. Elevation variance: 5,000 vertical feet from lowest valley to highest peak. Water sources documented in early surveys: 17 perennial springs, 45 seasonal springs. Carrying capacity before water development: approximately 20 head of cattle on native range. Carrying capacity after wells and tanks: 2,500 head. Terrain classified as rough or extremely rough: 40% of total acreage. Rock outcrops covering 15% of surface area. 0 year-round streams at lower elevations. In 1880, Edward B. Perrin purchased the float. He held the land for decades without developing it significantly. In 1936, he sold it to the Greene Cattle Company. Colonel William Cornell Greene had built a copper mining empire in Cananea, Sonora, Mexico, worth roughly $50 million at its peak. When his mining operations collapsed in the first decade of the 20th century, he focused on cattle. The Greene Cattle Company, formed in 1901, eventually controlled vast holdings on both sides of the border. 700,000 acres in Mexico through the Cananea Cattle Company, 100,000 acres initially in Arizona through various ranches and land grants. William Cornell Greene built his empire through cycles of spectacular success and catastrophic failure. The Cananea operations represented the peak. Greene discovered copper deposits near Cananea, Sonora, Mexico in the late 1890s while prospecting. The Cobre Grande mine showed rich ore, but developing it required capital Greene didn't possess. He went to New York with samples and audacity. The financing he secured from Eastern investors allowed him to begin operations. By 1902, the Cananea Consolidated Copper Company was producing ore. By 1905, it was one of the largest copper mining operations in North America. The town of Cananea grew from a few hundred people to over 20,000 within a decade. Most were Mexican workers. Managers and technical staff came from the United States. The operation was vertically integrated. Greene built a smelter on site to process ore. He constructed a lumber operation to supply mine timbers. He established a railroad connecting Cananea to the Southern Pacific Line at Naco, Arizona. He developed cattle ranches to supply beef to the company's store, feeding thousands of workers. At peak production, Cananea employed over 5,000 workers in the mine itself. The smelter employed another 1,000. Supporting operations added thousands more. The company town included hospitals, schools, a company store, housing for workers and managers, entertainment facilities. Greene controlled all of it. The profits were enormous, while copper prices remained high. Greene became a celebrity. The Colonel, he called himself, though the title was self-appointed. He built a mansion in Cananea. He maintained homes in New York and California. He entertained lavishly. He invested in additional mining prospects. He expanded his cattle operations. The Cananea Cattle Company controlled 700,000 acres of grazing land in Sonora. The herd numbered over 30,000 head at its peak. Cowboys worked line camps across the range exactly as they would later work the ORO. The scale was massive. Greene Cattle Company in Arizona started smaller. Initial holdings around 100,000 acres in southern Arizona near the border. But Greene continued acquiring land. The San Rafael del Valle Grant, the Palominas Ranch, the San Rafael de la Zanja Grant, additional parcels near Douglas and Naco. By 1910, the combined cattle operations on both sides of the border made Greene one of the largest ranchers in the Southwest. The herds moved between Mexico and Arizona depending on season and forage availability. Cowboys who worked for Greene spoke of the operation as if it was a separate country operating by its own rules. But the empire rested on unstable foundation. Copper prices fluctuated. Mine operations required constant capital investment. Labor unrest in Mexico threatened production. Greene's expansion had been funded by debt. When copper prices dropped in 1907 and 1908, the financial structure began cracking. The Cananea Consolidated Copper Company went into receivership in 1908. Greene lost control of the mining operation that had made his fortune. He still owned the cattle companies, but the mining revenues that had funded expansion were gone. Then, in 1910, the Mexican Revolution began. Cattle operations in Sonora became increasingly difficult as violence spread across northern Mexico. Raids on ranches, theft of livestock, danger to anyone associated with American ownership. Greene struggled to hold his remaining operations together. He put the Arizona ranch holdings in his wife Mary's name in 1910, perhaps attempting to protect them from creditors. He continued managing both cattle companies despite declining revenues and increasing problems. In August 1911, Greene was injured in a carriage accident near Cananea. He died from those injuries August 5, 1911. He was 57 years old. His widow Mary and his general manager Charles Wiswall, who would later marry Mary, took control of the cattle companies. They managed to hold the operations together through the difficult years of the Mexican Revolution and into the 1920s. The Cananea Cattle Company continued operating in Mexico until 1958, when the Mexican government expropriated all of Greene's former ranch lands in Sonora. 700,000 acres seized. The company received minimal compensation. The Greene Cattle Company's Arizona holdings became the sole remaining piece of what had been an empire spanning millions of acres and multiple industries. The Baca float purchase in 1936 expanded those holdings significantly, but compared to what Greene had controlled at his peak, it was a remnant. Cananea operations at peak employed 9,000 to 10,000 workers total. Greene's personal net worth at peak was $15 to $20 million. Cananea Cattle Company in Sonora covered 700,000 acres. The peak herd in Mexico numbered 30 to 35,000 head. Greene Cattle Company in Arizona by 1910 held 250,000 acres, not including the Baca float. Combined operations at peak reached 950,000 acres. Mexican government compensation, when Sonora lands were seized in 1958, was $2 million, Offered for assets the company valued at $20 million. The Baca float purchase price in 1936 was estimated $50,000 to $70,000. Baca float number 5, purchased in 1936 and renamed the ORO Ranch for its brand, became the northern anchor of Greene's Arizona operations. Greene had died in 1911 from injuries in a carriage accident. His widow, Mary, and general manager Charles Wiswall, who later married Mary, ran the cattle companies for decades. When the Mexican government seized the Cananea holdings in 1958, the Greene Cattle Company's operations became entirely focused on Arizona. The ORO developed specific characteristics: remote location, rough terrain. Cowboys who worked there lived in line camps scattered across the range, each responsible for watching 50,000 acres. They rode from dawn to dusk 7 days a week, checking cattle, branding mavericks, doctoring sick animals, riding fence line. The ranch ran a chuck wagon for spring and fall works. Cowboys would spend 2 to 3 months living out of the wagon, gathering and branding cattle scattered across the massive range. The tradition dated to the operation's earliest days. The chuck wagon operations on the ORO followed patterns established in the 1890s and refined over decades. Spring works began in early May, when calves born during winter and early spring needed branding. Fall works began in early September, when calves born late spring needed branding before winter. The wagon itself was purpose-built. Heavy wooden frame mounted on iron-rimmed wheels pulled by a team of 4 horses or mules. The chuck box at the rear held cooking implements, plates, cups, utensils, staples like flour and coffee and beans. Fold-down shelf served as work surface for the cook. Storage area under the bed carried bedrolls for cowboys, extra rope, branding irons, medical supplies for treating cattle and men. The cook ran the operation. Cowboys worked for him more than with him. He woke before dawn to start coffee and begin breakfast. Biscuits in a Dutch oven buried in coals, bacon or salt pork, beans that had soaked overnight, coffee strong enough to float a horseshoe. Breakfast served before first light. Cowboys ate fast. Then they caught horses from the remuda grazing nearby. Each cowboy needed several horses. The work was hard enough that rotating mounts was necessary. A horse used hard in the morning needed rest in the afternoon. Different horses for different tasks. Cutting horses for working cattle. Steady horses for long rides checking distant canyons. The wagon moved every few days following the cattle. Make camp near water. Work the area for several days, gathering cattle from draws and canyons. Brand calves. Treat any sick animals. Move to the next camp. Living conditions were basic. Cowboys slept on the ground in bedrolls. No tents unless weather turned severe. The workday started before dawn and ended after dusk. Injuries were common. Horses fell in rough country. Cattle kicked. Ropes burned hands. Broken bones, sprains, cuts required treatment in camp, unless serious enough to warrant the day-long trip to the nearest town. Wages in the early years were approximately $30 to $40 per month plus found, meaning food and basic shelter were provided. By the 1950s, wages had increased to perhaps $150 to $200 per month. Still low compared to town work, but the appeal wasn't money. Cowboys who worked the wagon spoke of the freedom. No boss watching constantly. You were responsible for your section of range. How you accomplished the work was your decision. The isolation suited men who preferred space to crowds. The work required skills that took years to develop. Reading country to know where cattle would gather. Reading cattle to anticipate their movement. roping skills to catch and hold animals for branding or treatment, horsemanship to handle difficult terrain and unpredictable animals, camp skills to repair equipment, treat injuries, maintain gear in field conditions. Some cowboys stayed for a season or two, then moved on. Others spent decades on the ORO. Coley Lyons worked the ranch from the Greene era through the Irwin years, a World War II medic who returned to ranching after the war. He knew the country, the cattle, the horses. Cowboys who worked with him described learning more from watching him work than from any amount of instruction. When Lyons broke his leg after his horse kicked up a rock, he rode to the nearest corner of Lake Mary, got off his horse, leaned against a fence, and rolled a cigarette while waiting for help. The story became part of ranch lore. You handled what happened without complaint. The country demanded it. The wagon tradition continued through ownership changes because the country demanded it. Gathering cattle across 257,000 acres of rough terrain couldn't be done with trucks and ATVs. The canyons were too steep, the land was too broken. You needed horses and cowboys who could handle horses and time to work the country properly. Modern chuck wagon operations made some concessions. Cowboys could bring more gear than just a war bag and bedroll, propane heaters in very cold weather, better medical supplies, radio communication with ranch headquarters for emergencies. But the fundamental pattern remained unchanged. Live out of the wagon for months, work the country on horseback, brand, treat, move cattle using methods developed a century earlier. In 1973, the Greene Cattle Company dissolved. The Baca float was sold to the JJJ Corporation, headed by John N. Irwin II. Irwin's great-grandfather had served as territorial governor of Arizona from 1890 to 1892. John Irwin II made his fortune in the East. When he purchased the ranch, his daughter Jane was a 21-year-old college student at Kirkland College in upstate New York studying English literature. She had taken English riding lessons as a child, but had never owned a horse. The family vacationed at dude ranches in Arizona, Montana, and Wyoming. After college, Jane became a sound engineer, working for 15 years in the music business. She toured with Stevie Wonder for more than 4 months. She met Larry Droppa, a fellow sound engineer. They married in 1985. When John Irwin II died in 2000, ownership of the ORO passed to his children, Jane Irwin Droppa and his brother John Irwin III. The ranch still runs the chuck wagon twice a year. Spring works from early May to early July. Fall works from early September to Thanksgiving. Cowboys spend months in the backcountry living as their predecessors did. The remuda includes approximately 100 geldings bred on the ranch for the specific work demanded by the terrain. The American Quarter Horse Association honored the ORO with the 2022 Best Remuda Award. The ranch runs cattle across terrain that requires horses with bone and stamina. It maintains 5 remote cow camps. It operates as working ranches as they did a century ago. The ranch has been closed to outsiders for decades. Photographers occasionally receive permission to document the operation, but it remains private land. The decision to maintain the ranch intact through multiple generations involves economics that don't appear in simple profit calculations. The land has substantial value. Yavapai County property records show values for comparable acreage selling for residential or recreational development. 257,000 acres divided into 40-acre parcels would create over 6,000 lots. Even at conservative prices, total value could exceed $2 billion. But fragmentation would end the ranch. 40-acre parcels can't support traditional ranching. New owners would expect road access, utilities, services. The infrastructure costs alone would be enormous. More fundamentally, breaking the land into small pieces destroys the ecosystem that makes ranching viable. Cattle need range to move across elevations following forage and weather. Break the connectivity and ranching stops. The Droppa family has chosen to maintain the ranch as a working operation rather than liquidate it for maximum value. That choice involves trade-offs. Property taxes on 257,000 acres are substantial. Operating costs for maintaining the ranch as a cattle operation run into hundreds of thousands of dollars annually. Wages for cowboys, maintenance on equipment, buildings, water systems, veterinary costs, feed supplements during drought years, insurance, and legal fees for water rights adjudication and property boundary issues all add up. Cattle sales provide revenue, but ranching in Arizona is marginal economics, even at large scale. Drought years mean reduced cattle numbers and reduced revenue. Market price fluctuations for beef affect income. The ranch may break even some years and operate at a loss other years. Water rights add complexity. Arizona's water law requires beneficial use to maintain water rights. The ranch's springs, wells, and catch tanks have established rights based on historical use, but maintaining those rights requires continuing to use the water. If the ranch stopped running cattle, the water rights could be challenged as abandoned. This creates a situation where preserving water rights requires maintaining ranching operations, even if those operations aren't maximally profitable. The water rights have significant value, but that value is tied to continued beneficial use. Modern challenges include pressure from neighboring development. Subdivisions expanding from Prescott increase property taxes in the area as land values rise. They create conflicts over road access, water usage, and liability issues when recreational users cross ranch property. Climate patterns show increasing variability. Longer drought, interspersed with intense precipitation events, stress range conditions and make consistent cattle operations more difficult. Years of good forage followed by years requiring herd reductions or supplemental feeding. The ranch employs modern technology where appropriate. Solar panels on some facilities reduce energy costs. Modern veterinary medicine improves cattle health outcomes. Digital record-keeping tracks breeding, vaccinations, and sales. But the fundamental work remains horseback and wagon-based because the country requires it. Current total acreage, 257,000. Current herd varies by conditions, 2,500 to 3,000 cow-calf pairs in good years. Cowboys employed year-round, 12 to 15. Horses in working remuda, 100 geldings. Annual operating costs, $1 million to $1,300,000. Annual cattle sales revenue, $1,800,000 to $2,400,000. Development value at conservative $8,000 per acre, over $2 billion. Annual property taxes, $100,000 to $150,000. Baca Float number 5 covers the same 100,000 acres, Watts selected in 1860. Additional purchases brought the total to 257,000 acres, the largest contiguous piece of private land in Arizona. Through the Mexican Revolution, the Great Depression, droughts, market crashes, and ownership changes, the boundaries have remained intact for 165 years. 2 floats from the same congressional act. Both 100,000 acres, both selected by John Watts on the same day, both approved through the same process. Float 3, selected land containing existing communities and mineral deposits, Sold to a mining company president despite non-mineral requirements. Opened to homesteading in 1908. Supreme Court validated it in 1914. Homesteaders evicted in 1917. Fragmented through legal disputes lasting until 1977. Today exists as separate communities, parks, and private holdings. Float 5. Selected vacant land without minerals. Sold to rancher Edward Perrin in 1880. Sold to Greene Cattle Company in 1936. Sold to Irwin family in 1973. Passed to Droppa Irwin ownership in 2000. Same boundaries, same function. Still operating as a cattle ranch. The initial selections explain part of the diversion. The buyers explain more. Perrin purchased land to hold. Greene purchased land to run cattle at scale, requiring vast, unbroken range. The Irwin and Droppa families maintained it as a working operation. Each owner of Float 5 faced economic pressure to subdivide. 257,000 acres near Prescott. Developers would pay enormous sums even for portions. Each owner maintained the boundaries intact. The speculators who owned Float 3 faced different calculations, legal battles to confirm ownership and clear competing claims, mineral extraction opportunities, community developments on portions, fragmentation through sales to different buyers. The outcomes reflect those calculations. On Float 3, people who filed homestead claims under federal law, published in 1908, lost access to land after the 1914 Supreme Court decision. They had invested years proving up claims the government told them were legal. The court ruled the government had erred when it opened the land to homesteading. The homesteaders lacked resources for prolonged legal battles. The speculators could afford Supreme Court appeals. On Float 5, property rights transferred through standard purchase agreements. Perrin to Greene to Irwin to Droppa. No one built a life expecting permanence only to lose access through legal reversal. Whether law protected or enabled dispossession depended on which float, which selection, which buyers, which timeline. The full Baca float systems varied outcomes across all 5 grants. Float number 1 in the Jemez Mountains west of Los Alamos took its own complex path. The Baca heirs retained this float when they sold the others to Watts. Portions were sold to Mariano Otero and other Santa Fe Ring members in the 1890s. The land included what would become known as the Valles Caldera, a massive volcanic crater with rich grassland. The float became a working ranch. Sheep initially, then cattle. Timber operations harvested ponderosa pine from the higher elevations. The property changed hands multiple times through the 20th century. In 2000, the federal government purchased 95,000 of the float's 100,000 acres for $101 million, creating Valles Caldera National Preserve. The acquisition ended over a century of private ownership, bringing the land into federal management. Float number 2 on the high plains north of Tucumcari was sold by Watts to Canadian speculator Wilson Waddingham in the 1870s. Waddingham combined it with the adjacent Pablo Montoya Grant, creating the Bell Ranch. At its peak, the Bell Ranch covered over 650,000 acres, making it one of the largest ranches in New Mexico. The Bell Ranch operated continuously as a cattle ranch through multiple ownership changes. Unlike Float 3's fragmentation or Float 5's isolation, Float 2 became integrated into a larger ranching operation early. The ranch still operates today under the Lane family ownership acquired in 1970, 292,000 acres. Working cattle operation offering some recreational hunting and tourism to supplement ranching revenue. Float number 4 in the San Luis Valley near Crestone, Colorado, had perhaps the most unusual trajectory. Watts sold it to parties who lost it through tax default. It passed through various owners in the late 1800s and early 1900s. The ranch operated cattle and sheep. Mining occurred on the margins, but never became dominant economic activity. In the 1970s, a portion was subdivided into the Baca Grande development near Crestone. Unlike typical subdivisions, Baca Grande attracted spiritual and religious communities. Buddhist centers, Christian retreat facilities, New Age organizations established presence in the area. Developer Maurice Strong and his wife donated parcels to various spiritual groups, creating an unusual mix of working ranch land and spiritual retreat centers. Water rights controversies emerged in the 1990s when development companies proposed exporting groundwater from beneath the float to growing Front Range cities. Local opposition and environmental concerns defeated the export plans. In 1999, the Nature Conservancy purchased the remaining undeveloped portions. The land was subsequently transferred to federal ownership, creating Baca National Wildlife Refuge and additions to Great Sand Dunes National Park. Of the 5 floats, only number 5 remains entirely in private ownership, operating substantially as it has for over a century. Number 1 and 4 have become federal lands. Number 2 has become part of a larger private ranch operation. Number 3 fragmented entirely. The outcomes reflect the physical characteristics of the land, the legal controversies surrounding selection, and the economic calculations of successive owners over 165 years. Each float was 100,000 acres authorized by the same congressional act. Each was selected by the same attorney on the same day. Each was approved through the same administrative process. Yet the stories diverged completely based on what happened after that initial approval. Today, if you drive south from Prescott and turn west toward Seligman, you'll reach private land marked with no trespassing signs. Beyond those signs lies Baca Float number 5, cowboys riding, cattle ranging. The chuck wagon rolls out twice a year, as it has for nearly 90 years. You cannot visit without permission. The ranch does not offer tours. If you drive south from Tucson toward the Mexican border and turn off near Tubac, you'll pass through communities built on what was Baca Float number 3. Art galleries occupy the area. Rio Rico's subdivisions spread across the land. Tumaca Corey's mission, ruins draw tourists who learn about Spanish colonial history. 2 grants from the same act of Congress. Same size, same legal origin, same selection process. The divergence happened through choices made after selection. Which land Watts chose, what those lands contained despite legal requirements, who purchased them, how courts ruled when conflicts emerged, whether people who had built lives under one legal framework lost everything when courts applied different frameworks retroactively. The Homesteaders on Float 3 followed law as published. They filed proper claims after the land office opened the area to homesteading. They proved up their homesteads. They invested everything. The speculators followed different procedures: property law, contract law, appeals, Supreme Court precedent. The speculators hired attorneys experienced in land grant litigation. The homesteaders could not. Both groups operated within legal systems. The systems produced different outcomes. On Float 5, property transferred without forcing that calculation. No one proved up a homestead believing they followed valid law, only to discover years later that law had been issued in error. If you found this investigation compelling, subscribe for more stories about Western land history, legal battles that shaped ownership, and communities that disappeared. Leave a comment telling me which controversial land grant we should examine next. The Maxwell Land Grant in New Mexico, where conflict played out on even larger scale. The San Rafael del Valle Grant in southern Arizona, where Greene Cattle Company fought Mexican and American legal systems simultaneously, or perhaps a forgotten homesteading area. The Baca floats were born from the same compromise. Identical in size, equal in legal status, approved by the same government. One became a place where wagon-based ranching continues because each owner maintained the boundaries. One became a place where families lost everything they'd built under homestead law after courts ruled that law had been issued incorrectly. Two grants from the same act of Congress, same size, same legal origin, same selection process. The divergence happened through choices made after selection. Which land Watts chose, what those lands contained, who purchased them, how courts ruled, whether people had resources for legal battles lasting decades. The Homesteaders on Float 3 followed law as published. They filed proper claims after the land office opened the area to homesteading. They proved up their homesteads. They invested everything. The specifiers followed different procedures: property law, contract law, appeals, Supreme Court precedent. On Float 5, property transferred through standard purchase agreements, Perrin to Greene to Irwin to Droppa, 165 years, 2 floats, both legal. So who deserved Float 3? The specifiers who bought it, or the homesteaders who built on it?